Hello, everyone. This is Kyiv Legal Hackers. My name is Dmitry Foremny. I'm happy to invite you to today's discussion about remote courts. I will be the moderator. As for my background, I'm a head of the Justice Accelerator and co-organizer of Kyiv Legal Hackers. But we're also going to have a few wonderful panelists today that I will introduce shortly. First, I would like to say that Kyiv Legal Hackers has two wonderful partners this year. That's Vasilki Silin Partners and Liga Zakon. We are grateful to them for their support. They are top teams and building top products. Okay, so now we can switch to the main part of our event, and a short remark that you probably know that to ensure the ongoing access to justice, governments, and judiciaries are rapidly introducing various forms of remote courts. It could be audio hearings, it could be video hearings, it could be paper hearings even. So everything is changing at a remarkable speed, right? Different things are being developed so quickly. So that's why we decided that it would be very useful to discuss approaches of remote court hearings in different countries. And today we're going to have few speakers from few countries. Now I will introduce all of them one by one. So first of all, I would like to warmly welcome Ivar Taulo. He's a key expert on e-justice at the European Union project called Pravo Justice. Hello, Ivar, how are you?
Hello, I'm doing fine. You hopefully too.
Great. Would you like to say a few words about your background?
Oh, well, I wrote you. I'm a dinosaur of e-governance. Well, when you are the legal people, I'm actually from the IT community more. I've been dealing with it since mid-1990s, and I happen to have the dubious honor of writing original Estonian policy for digitization. So I've been dealing with it for more than 25 years, but now today I'm in Estonia, but otherwise I am in Kiev, working in this Pravo Justice project and trying to help the justice sector also to pick up the new technologies.
Wow, very interesting. Thank you, Ivar. So now I'll switch to the next speaker. So we have Darren Howie. Let me bring him in. Hello, Darren. Darren is the chair of the technology subcommittee on bar association in the UK. Darren, would you like to add a few words about your background? You're on mute, by the way. Oh, sorry, Darren, we can't hear you, unfortunately.
That's better.
Oh, yeah,
now you can hear me. Yeah, I'm a practicing lawyer. I drifted into dealing with technology for, particularly for the family law bar and the family court in England, at the tail end of last year. And it's been a very steep learning curve ever since. And I'll explain why when I speak.
Oh. Okay. Very interesting. Thank you. So next, I would like to introduce Larry Bridgesmith. He's the chair of the Dispute Resolution Commission of the Tennessee Supreme Court. He's also a managing partner at Accelerate Insight and co-organizer of Music City Legal Hackers in the US. Hi, Larry.
Hi, great to be with you all. And I just have to say that if Igor is a dinosaur, I must be the amoeba that crawled out of the swamp, because I've been practicing law for 40 years and I can't wait for this conversation. So thank you for inviting me.
Thank you very much, Larry. So last but not least, I'm adding here Stefan Ide, who is a partner at Ben Ibler Rech. Okay, I'm not gonna pronounce it. Sorry, Stefan, you have to do it for me. He's a partner at a law firm that he will name himself. He's also an investor and a co-organizer at Vienna Legal Hackers. Stefan, please say a few words. Stefan, please say a few words about yourself. I'm sorry for not getting the law firm's name properly. Okay, and you're on mute. Oh, nope, not yet. Could you please try to unmute yourself? Okay, we can hear you. We can see you, Stefan, but unfortunately we can't hear you. Could you try to push the unmute button on the bottom? Should be on the bottom of your screen.
Yeah,
oh,
yes. Now it works. Sorry for all of that. Jesus. And for that, I did study informatics. Yes, what shall I say? What shall I say? I have an education in law and informatics. I wrote my master in informatics on legal expert systems, practiced law for not as long as all of you, but for the last 30 years. I'd been in big law for many years, group head in a big law firm, an international one. And the last 10 years, I'm more focused on my legal informatic interests. I run here a group that mixes 50-50 of people who do coding and informatic implications, as well as a law practice. And so I'm very excited to be here and to share my experience on the one application I'm going to introduce.
Thank you so much, Stefan. Now I feel a little bit like I'm in the kindergarten, you know. So I will not talk too much, but I will give the floor to people who really know what they're talking about. And by the way, we have live streams on Facebook and YouTube. And people over there, hello to you. I will bring some comments up. If you have any specific comments, please comment during the presentations, and I'll read out loud your comments, or I will just bring them to screen like this. Okay, so we have Melissa here saying hello to Darren and a few other people. Okay, great. So we're gonna go like this. I will first give the floor to Ivar. He'll have about 15 minutes to present his ideas, and then we're gonna have about 10 to 15 minutes to discuss or comment, and then I'll switch to the next speaker. So for now, I'll bring everybody except Ivar to the back for a while. Okay, I'll do like this. Okay, you're now in front, Ivar, and I'll also hide behind the scenes, and I give the floor to you. You can give me a sign. Yeah, you can scratch your nose if you want me to switch the slide, or you can just say, please go to the.
Don't worry, I can just say yes. Okay. So shall I start? Thank you very much, Dimitri. Ladies and gentlemen, fellow hackers and panelists, Dimitri said that I should present my ideas. I understood my task was a little bit different this time. I do profess I have still ideas despite of my age, but first of all, I tried to implement these ideas in my everyday work in Bravo Justice. And when the COVID quarantine regime hit, we were immediately thinking of the same things that we are doing or you are doing today. we organized on April 30th a webinar on the remote administration of justice, making use of our good cooperation with an institution in the Council of Europe. It's called CEPE. It is European Commission for the Efficiency of Justice. And as a European sort of commission, it has many people from different countries. So we brought in a quite similar fashion together people from 11 countries as a panelists. And I believe we got, we broadcasted also this meeting, and we got some 3,600 views at the end of the day. But I'm not to talk about that, but just that there was an interesting moment, if I just kind of sum it up, as a Swedish presenter said quite obviously why, that, well, we didn't really have much difference in our court's work, maybe about 10% less activity. But you know, the Swedes are one of these countries that didn't establish any specialized regimes. But the second speaker, who also said that they didn't experience any big changes in their work, was Estonian judge. And I had heard it from my other Estonian friends as judges also, that, well, basically, maybe it is less, I mean, obviously there were less meetings, physical meetings, they were cancelled in Estonia. It was also full quarantine, but the work was going on quite in the usual way. This is because we had already gone over to the video conferencing. But that brought us to the question later with my team and with other Ukrainian participants that they were asking, okay, but how should we get there? What should we do? And you know, there was there have been attempts in Ukraine. There has been a judge somewhere in the east, a country called Dnipro, I think, who used Zoom for the court meetings, and now there have been others. But so there was, I mean, there has been this kind of big overhaul of Ukrainian court systems, IT support. And it's called the SITS, or United Judicial Information Communication Technology System for the courts. And this reform is ongoing already for a couple of years, maybe not too successful at the moment, but nevertheless. And there is a RADA committee that is kind of helping this eSITS project to succeed and push forward. And they asked us, the Prava Justice, about whether we would be, we could kind of be as a bystanders evaluating the different possibilities that Ukrainian courts have. So my talk today and the next 5 to 7 minutes is to sum up really this findings that we've had. We published it very quickly. The committee asked us to do the work very quickly, and they have caused some controversy. Maybe some of you have heard, but then we took some more time and added something, and you would be basically in a privileged position to be the first ones to hear the results of the updated surveys that we did. So let's go to the next slide, or to the basically what we wanted to do really is to compare different systems, and we can go actually to the next slide right away. And we didn't want to take any political stance. We basically said we'll do this kind of technological comparison and procedural comparison of the possibilities of these systems. And so we had people from the IT background doing this, and we had people from the legal background. I mean, my team who were doing it. And so we established first the methodology, sort of how we approach it. Then we chose the systems. So we can go to the next slide. You will see the systems. It is not, I mean, there is no secret which systems we took. We took the ones that we felt are relevant currently to the Ukraine. There are systems around the world that also have this kind of the same functionalities. But we didn't use them because they were not somehow connected to the Ukrainian experience. So there were, but what we chose first 4, and then we added in the upgrade also the Microsoft Teams and TrueConf. And then let's go to the next slide, and then we evaluated these systems, which, I mean, everybody will recognize them anyway, with this evaluation criteria. As I said, part of it was procedural ideas, part were technical items, and it was also initially through the brainstorming, and later because we got the feedback and there were different questions and quite justified why we left something out or added something. So we clarified it, and this is the list. I'm sure you somehow will be able later to see this separately if you want to, but let me go to the we then took this criteria. Let's go to the next. So we created a comparative table. We gave evaluated every single item. 0 was that it wasn't in existence. 3 was that everything was fine with it. 1 was obviously that some basic functionalities were there, and 2 was the most of the necessary functionalities were there. So initiation of video conference, this connection of the participants, identification of participants, moderation of video conference, what we saw here, for example, whether you can, as a moderator, mute somebody, or you can other way around, open their microphone remotely, which are kind of important things for the court cases. So, I mean, we can go through all this list, but I believe you will be able to do it yourself, and you will see that they have this. You can find easily the justifications of this. When we go to the next slide, we'll see the technological items. And so the first and most important, I believe, I mean, for me, whereas these procedural ones we took sort of going down the list of the procedures, then with the technology ones we looked kind of, we tried to also somehow reflect how we felt, what is more important or less. But in the mixture at the end, it doesn't matter really. But when you see it, I think one of the problems was this is a requirement to the communication channels, because there are different technologies how to stream the information flows, and they have. You have to. I mean, it is one thing to do it in Estonia. Or Lithuania, or I don't know, Finland. We have fast internet, and it is pretty much ubiquitous everywhere. But with Ukraine, outside the big cities, it is still problematic. But in big cities, it should be okay with everything. But what is there clearly a problem, what we saw also, one of these, and the favorite for the court administration nowadays, the EasyCon system, it's not using the streaming optimization soft from the server side. So you can't really have a normal transmission outside very high-speed internet. For example, when we tested it, I was in Estonia, and I thought I have fairly high-speed internet at home, and it was freezing up all the time. And just because it is differently modeled. And Zoom in that way was the easiest one. But I mean, okay, we went to the next slide already. Let it be. Let's see slide B. But I'll just comment some more on these technical items. We were also looking, obviously, the requirements to the equipment, the quality of audio and video itself, usability of the interface, security. Questions with GDPR, I mean, data protection, personal data protection questions, and these demands of regulatory demands, actually, of security in Ukraine, which is the KZZI, or комплексная система защиты информации. I mean, this is totally Ukrainian thing. But also assignment of usage rights, technical support. So we evaluated all the systems. As you see, they got these points by basically 8 different experts, and it was a point average. And now we can go to the results table, or results. I mean, so the smallest score was by far was by EasyCon, and as I said, for me, the basic problem was required functionality. I mean, they don't. You can't really use it normally at this stage with this level of readiness. And let me hasten to say that as it is a favorite one for court administration in Ukraine, then I think that Ukrainian courts will have very hard time if they are going to use it and take it. I understand the reasons of promoting it by the court administration can be not technical, but legal and whatever else. But I think that it's not going to really work. Yes, it has identification. You can use digital signature to send some documents, but there are so many minuses that don't work that I'm feeling quite confident telling that it's not so good. And let me go a little bit further. Yes, obviously Zoom I'm not going to talk that much about, but it clearly, by the way, has it consumes the bandwidth in the most economic way. And is otherwise also very smooth, and you all know that it has been enjoying worldwide very good sort of press, except some questions of security. Skype, by the way, was also not very good because it has, I know Skype for a very long time. I was a beta user of Skype back in 2003, I think, starting. What happened was that when Skype became part of Microsoft, then the developments kind of stopped, and they did something, and it hasn't been so good. So it provides initial sort of things, but not that much more. So let's go to the final slide. Some more results. You see the other three. Microsoft Teams 43 score, WebEx actually got the highest score, and TrueConf also there. So basically all the four were within the margin of error range, I would say. They all do the job and can be used. Every one has something sort of more positive, something more negative. What I would want to wrap it up and say is that whereas is a lesson that I would want to tell the legal community is that with e-governance, when we actually initially we started to write kind of the chosen software into the regulatory documents and say that, well, okay, this is what we chose, this is what you should use, but that was sort of at the end of 1990s. We realized very quickly that by doing so, we do the disservice for the user community. We should establish open standards, but not give preferential treatment to any given system. And I believe in the COVID situation, what we have seen and what I have read from the other court systems and this remote sort of practice is also a very healthy approach when you leave this to the judges to decide for themselves what they feel comfortable within the certain framework, of course, and there are questions of financing now this that need to be decided. We have also talked about that in our research that you can look, but I'm not stopping it on this here. But generally, let the people, let the courthouses decide themselves how they feel comfortable. And as Dimitri said in his introduction, that it could be even the telephone like the US Supreme Court is doing, or it could be some other means. Let's just hope that we'll get over from this initial things that virtual reality somehow is dangerous and unstable and not good enough for our communication. I believe the COVID situation has shown that it is possible to work remotely, and the ice has been kind of moving, and pretty soon a lot more people and procedures will be online. Thank you very much.
Thanks a lot, Ivar. I will now bring back all of our colleagues, but in the meanwhile, there was one question from Alexander Baranov. He was asking why blue jeans was not evaluated in your research. Can you comment on that?
I'm sorry to say it didn't come up even as a suggestion when we initially did this sort of round of what should be evaluated. As I said, okay. we didn't aim to be perfect. We just took those that people were kind of in the community that we were dealing with were interested.
Mm-hmm. Okay, I got it. Now I give the floor to all other panelists. Larry, Darren, Stefan, would you like to comment, or do you have any specific questions? I can bring back the presentation if you want. Please feel free to unmute and comment.
Mm-hmm. Well, I jump first, if that helps. You know, the key question for me is always: is there a definition what security standard needs to be met, and then there is a test whether or not one or the other application does meet that standard? Is that somehow written down, and can there be the checks and balances for that?
Well, it's a very good question, but I mean, we first of all oriented our research to the situation in Ukraine. I mean, in general, I could tell you forever about security standards, as you probably could tell me. I mean, I was rapporteur for the Cybercrime Convention in the Council of Europe, so I'm very well aware of the importance of cybersecurity since 1990s already. But what concerns Ukraine, they have a very clear standard, which I think is actually detrimental to Ukraine, because the standard was set in late 90s and hasn't been really much changed. Which means that whenever they are bringing in a new IT system, then the certification of the system to correspond to the standard will take a year or a year and a half as a minimum. And that really is not sustainable way of innovation. But because it is the actual regulation, we had to take this into account. The very big systems or providers of software usually have their deals, and they get their systems evaluated, as you could see also in our research, the Microsoft's Cisco, but the others, they generally don't care. And then it is a question for the Ukrainian judges whether they kind of risk to go without this confirmation or not. But Sarah, it's not only technical question. What we found in our previous workshops that we had on April 30th was very interesting. There were a couple of judges that were saying, well, but why do you need identification of the persons? I mean, I don't, as a judge, I haven't really felt the need to. I've been judge for 30 years, and I haven't had somebody to misrepresent him or herself. So it is a different legal traditions and the norms that come from there that should be also looked at, not technological standards. Thank you.
Okay. Thank you, Ivar. Okay, while other speakers are thinking about their comments, I can bring up one more from the same person, from Alexander. He's saying the TrueConf system was developed in Russia and can have backdoors injected by government. So it takes us back to the cybersecurity
Yes.
discussion. Do you think so? Do you think this is a correct statement?
I think, yeah. Well, first, no, the statement as such, well, it could, and there are methods to counteract it and to say that it shouldn't be a problem. I mean, if it is run on the local servers and the traffic is filtered, you can organize it the way that this threat, if it is called a threat, would be redundant, would not be there, because but the question was. There was one of the things that was in the minds of Ukrainians. There was this EasyCon and TrueConf. Sort of one is very good to use, and another is sort of not so good. But yes, a good one belonging to Russia. And there were there were other questions, political questions. Do we want to pay Russians the license fees? That is another thing. But it is not. Life is never black and white, because actually the big team of developers of TrueConf are actually in Kharkiv. So it is kind of local people that are developing it at the same time. So there are a number of questions. I believe if the politics would not have interfered, it would have been it would be easy for Ukraine to use TrueConf, because there are already a number of systems that are using it and people are familiar. However, when you look at other systems, especially like Zoom, which is really very nice and intuitive, it is easy to learn to use it as well. But it is also with the same, I mean, as I said, I think this technology has come to an age already, and it isn't that important which one you use. Just take one that you mostly like the features and then work around this.
Okay. Yeah, got it. Thank you. Darian, Larry, do you have any comments for Ivar?
No, I just agree with the last comment that if remote hearings, in my experience, and I also sit as a judge as well as a practicing lawyer presenting cases, and their effectiveness really largely depends on the capability of those participating to use the technology. And so if the judge has a favoured platform that they are able to use and they are happy with the features, as do the lawyers who are appearing in court in front of them, then that is the platform they should choose. And I will say a bit more about that when I give my short presentation.
Great, thank you.
Added is to Ivar's observation about this rate of change that technology is capable of, as opposed to the rate of change that regulatory bodies and governments might be. Because how do you keep up with the availability of enhanced technologies when it takes so long for government to process the political channels approval of one versus another? And that's a problem we're going to have to deal with as this exponential age continues to unfold.
Well, yes, that is clearly the case. If I may just to quickly respond to that, I mean, as I've been dealing with it, I helped to write the first internet laws altogether, sort of in Estonia, and later some regulations for the EU. What we did when how we got this kind of kickstarting started very well in Estonia was well, first we said that we don't want to have a perfect law. You have to find the balance between this kind of need to fix something already in the law and the flexibility later on. And it is tricky, but even the European Union, I don't know if it does it today, but in early 2000s, some of the regulatory acts that were dealing with IT questions, they were they finished with a promise that well, we'll enact this law now, but we will come back within 2 years to review what was there. So I think that this is a very sensible approach. I know the old European countries, so to speak, are more suspicious toward speedy changes, but I come from this country that has undergone so many changes that I have probably a little bit more simplified view of it, and plus I'm a philosopher, not a lawyer, so.
Okay, you were yes. Thank you. Probably the last question was, okay, you got this research and now even presented us the second version of it, which is great. We did the first sneak preview, I would say. Thanks a lot for that. And my question is, how will it practically be used? Do you think it's going to be used by Ukrainian court system to make a decision on it? So do you think Ukrainians will act on it?
Well, that is a question that you should answer more probably. I can only say that we have seen what I have seen. I mean, I've been working now in Ukraine and with court system, among other things. I mean, also the justice system under the Justice Ministry. But what I have seen is that as opposed to the private sector, where Ukraine has a very good competence, generally in IT management, issues in the government are rather poor. And I mean government at large, not just thinking the executive, where now there is a Ministry of Digital Development, and previously was e-governance agencies that were doing a good job. When we look at the Ministry of Justice, there is even no point person who deals with IT. I mean, they have only help desk to help to fix the computers, but no systematic thinking. The same in the justice sector, unfortunately, or I mean the court system. When I started to evaluate what was there, then everybody was telling me that Dubinko knows, and I called it a Dubinko syndrome. He was a director of the IT enterprise under the court administration. And everybody in words says that, oh, this is great and we want IT. But when they make decisions, then they don't want to know the details. They still takes IT as being something very technical. It is done by the guys with greasy hair that are in the basement behind the elevator shaft. And actually, if you look around in the developed world, these IT guys have been brought to the policy making level. at least the sort of leadership in the structural way, and integrated immediately. And that hasn't been done in the court system. I mean, we are trying to, as a Pravo Justice, we are trying to teach High Court of whatever it is, Justice, High Council of Justice, and others that look, you should yourself think through it, what you want, and then the IT people can do it. But I mean, it has to come to you. So with this research that we have done, yes, well, we were asked by the RADA. The RADA people wanted to know, and they are asking very qualified questions. When we go to the court state administration level, then I think their problem is that they take it first as a technical issue, and then they ask the technology people to do it, whereas the lesson from the wider IT community in the world is that we have now as the main principle user centricity. And somehow it doesn't get into neither the government administration nor the court administration yet, that you have to put the user into the center of these developments. So, well, let's hope for the best, but I think there is still quite a lot of work to do in Ukraine. Thank you.
Yes, thank you so much, Ivar. Thank you for presenting this very interesting research. Unfortunately, colleagues of Ivar, Dovidas and Anna couldn't join, but I think it was a fruitful discussion. Thank you so much, Ivar. So now I want to give the floor to Darren Howie to share his experience as a judge, as a sitting judge, but also as a lawyer who also teaches other lawyers how to use technology for court hearings. Please, Darren, the floor is yours, and we're going to the background.
Thank you. I'm going to share my screen, and let's do that, and then let's do that, and play from the start. So when I've been teaching lawyers in England to use their technology, I have started with this slide because the advance of COVID-19 has required us to hold sessions on Zoom that have lasted 2.5 hours to teach people how to use their technology. And that's been on behalf of the Family Law Bar Association of England, Wales. And I fell into the role of being the chair of the technology committee. I'm a good user of technology, but I certainly don't really understand how it works. Now, I've got 15 minutes and then a 15 minutes Q&A. I may steal some of the Q&A time by running over a little. But what I want to do is really provide a summary of how remote working has developed in the English court, specifically the English Family Court, which is where I ply my trade as a lawyer and where I sit on a part-time basis as a judge. And then I want to end by demonstrating why whatever video conferencing platform you are using, my experience is that that needs to come hand in hand with effective paperless working. Now, COVID lockdown was imposed in the United Kingdom quite late in comparison to other European countries. It wasn't until the 23rd of March that we had a lockdown imposed. Prior to then, the court service had for a number of years been undergoing a modernisation programme that was, from the perspective of a lawyer at least, appearing in the courts, pretty much invisible. We were told of millions and hundreds of millions of pounds being spent on upgrading the court estate, so that's the buildings, but also the court IT. And really all we saw were some screens that appeared on the judicial benches that were not actually connected to anything and were generally pushed to one side as they just obscured the judge's view as a witness box. Whilst outwardly nothing appeared to be changing from this modernisation programme, internally within the court service, projects had been established to set up a remote working video platform specific and bespoke for the court. It had commissioned software developers to come up with a bespoke system long before COVID-19 hit our jurisdiction. Of course, with the march of COVID-19, that long-term program required a rapid advancement. But of course, that could not happen overnight. So what then happened was that courts of different jurisdictions, so the criminal courts, the civil courts, and the family courts, all adopted slightly different practices to achieve the same goal. And that goal was keeping access to justice available despite the challenging conditions. And in my jurisdiction, the family court, it was the president of the family division, who's our most senior family court judge, who initially opted for Skype for Business as the chosen platform for the family courts. We knew lockdown was coming, so guidance was issued by the senior judiciary shortly before on the 19th of March that made remote working the default position. So people doing my job were almost overnight expected to work in a different way. Doing new things, many thought we were being asked to do the impossible. We've already had observations about how slow investment can be in government services, and indeed how slow established legal practitioners can be in adopting technology and new ways of working. And many thought we were being asked to do the impossible. Now, what I find impossible is I find it impossible not to touch my face. But I don't find it impossible to use technology as long as it's used in a targeted way. And I am taught those parts of the features that I need to use. I need to know how to turn on my remote video platform. I need to know how to stop someone interrupting, how to turn their mic off. I might even have to turn their video off. I might need to know how to authorize somebody else to share their screen and show me documents. I might need to know how to share documents myself. So when approaching remote working, we very deliberately adopted a education program that just taught the lawyers those features of the software that they actually needed to perform their functions in a remote court. There was no point asking a practicing lawyer with a very busy diary to sit in front of a YouTube video to watch a demonstration on how to use a piece of software. I said I think in all of my training sessions that if I have a cold bottle of white wine in the fridge, you're very unlikely to get me to sit and watch a YouTube educational channel. So we had to work out what we were going to do, what platform we were going to use, but accepting, I think, that we were on a very steep learning curve. So mistakes would be made. And our view, or particularly my view, was really the first mistake that was made was really to suggest that one system should be used. So initially the suggestion was that Skype for Business would be used. It's an old Microsoft platform. It's no longer supported by Microsoft. It has poor functionality and, in my experience, unstable connectivity. And you don't want that in a remote hearing because someone's in the middle of speaking and then they just drop off the connection. But it was used in England because it was something that the court service had already paid for, and some of the judges already had it. So why pay for something new if you've got something that might work? Similarly, some of the judges had Microsoft Teams subscriptions. Far from all of them. Many don't, and many still don't. Better functionality on Microsoft Teams, better stability, but of course it's less accessible to the lawyers themselves. It comes as a cost if the lawyers' firms want to buy their own subscriptions, hold their own meetings, and of course many firms and partnerships are reluctant to add to their overhead costs, particularly in publicly funded areas of work, such as the work that I do, where financial rewards are small. England has a divided legal profession. So we have what we call barristers and we have solicitors, where the barristers are the specialist court advocates who organise themselves in sets of barristers' chambers that are really nothing more than a cooperative sharing administration charges, but having their own corporate identity. And so everyone's self-employed. One of the consequences of that is that the barristers were ahead of the game, as their chambers had already invested in video conferencing platforms such as Zoom, and another one we used called Lifesize. And we had in our Family Law Bar Association already established, long before COVID-19 appeared, an educational program for the family bar to be taught in person, because there's no point doing it at arm's length, we thought initially, to work paperlessly. And by working paperlessly, I mean not walking to court with a large bundle of paper documents that form the papers and the evidence that the court is going to consider. That should all be done digitally. So when COVID-19 hit in England, we already had an educational program up and running, which we then just adapted to add to it, working remotely on a video conferencing platform. And a dual purpose very quickly arrived for that education, where the lawyers and the judges understood that remote hearings had to be done to keep the justice system open, to ensure that urgent cases could be heard. In my field of child protection and domestic abuse, victims require protection, some say even more, during a lockdown period. But the alternate purpose that also developed, I think advantageously as it turned out, was that the barristers who I deal with had to learn to work remotely, to continue to earn fees, to continue to make an income. And financial survival is a powerful motivation for people who had so far, or many people who had ignored the advance of technology, to become familiar with it, and all became very determined to make it work. To give you examples, in the space of just a few weeks, we trained approaching 200 lawyers to work with PDF management software, electronic court bundles, and video conferencing platforms. One of the online sessions that we had, which I've already said were about 2.5 hours each, were attended by 520 attendees on Zoom, by far the largest educational conference that had been held by the Bar Council of England and Wales, all brought about by the advance of COVID-19, the need to remote working. And all those that had ignored the offer of education prior to that were rushing to take it. And indeed, over the space of a weekend, so between the issue of the guidance on the 19th of March, the lockdown on the 23rd of March, me and my team, we drafted user guides for the 4 main video platforms that were already being used, but being used in a different way. And again, we wrote those, setting out the features that the lawyers needed to know rather than confusing people and making it seem like an unattainable task by wanting them to learn everything that all of the software can do. But what has happened in England at the current time is we've ended up with an almost two-tier system. I'll explain why. The more senior judiciary, specifically the judges involved hearing long, complex trials lasting a number of weeks that involve many parties and many lawyers and many witnesses. And judges who are of a more senior level, who are perhaps less influenced by the managers in the court service itself, are willing, very willing, to use any platform that does the job. And particularly platforms at the bar that the lawyers presenting the cases are familiar with, because it's in that way that the case is best presented, that the court users, the parties, are assisted to participate to the degree that they wish and the degree they need. So we have a system where some judges are willing to use anything that the lawyers suggest, subject to security assurances. And it's right to observe that particularly the use of Zoom, we were being told to start off with that Zoom was not secure, but there's been constant updates and security releases by Zoom to the degree that many judges are very happy to use it. But we still have a different tier where they're more junior judiciary, and bizarrely, in my opinion, the very senior judiciary in our Court of Appeal are stuck using Skype for Business, which, as I say, it's poor functions. You have 4 tiles and you can't see, really, you can't engage with the witness if you're cross-examining a witness on the screen. The bespoke platform development that the court service had commenced was advanced. It is running in some courts. We call it CVP, Court Video Platform. I'm afraid it's already got the nickname of COVID Video Platform, something I suspect that will endure. It's good. It's much better than Skype for Business. It's controlled by the court service. Its connectivity can be unpredictable, and it's still not available in all courts. The original version did not include the capability to make an audio recording of the proceedings, obviously something that, if you're working in the court itself, is essential, but that is now being introduced. So on the whole, the judiciary in England in the family court, where I work, have adapted extremely well. In a recent High Court case, the judge hearing the case said the following: the use of Zoom application has so far permitted an effective hearing without anything more than the occasional and minor technical glitch as bandwidths fluctuated. The vast majority of both evidence giving and the hearing of submissions has so far taken place very effectively from the court's perspective. Screen sharing of documents has been very effective, and indeed, in almost every way, more effective than by the use of hard copy paper bundles in court. Legal teams have rapidly familiarized themselves with the remote technology and have become adept at using it. Cross-examination on even the most contentious aspects of the expert evidence was effective. From the perspective of the court and the lawyers, I have little doubt that the remote technology would provide an effective means of the evidence being adduced and tested. Now, the problems, in my opinion, with fully remote working in the justice system are the difficulties experienced by the clients themselves, maintaining previous standards concerning client care and client participation. In my field of child protection, meeting and forming a relationship with a client is extremely important. If they don't trust me, they will not open up. If they don't trust me, they will not engage. They won't have built confidence in me. And so there needs to be in-person meetings and consultations. So they are happier with my ability to represent them and their views in court, even at an arm's length way during the remote hearing. For myself, I am happy with the remote court experience. I feel it's more intimate and more connected. But again, that depends on the system you use. On Zoom, if you select speaker view, my face can occupy the whole screen for the witness or the judge, and the witness's face can occupy the whole of my screen. So it can be a more intimate experience than cross-examination or submissions making from a distance in a large courtroom. But it does, as I said earlier, require familiarity with the software. The effectiveness of a remote hearing really is very much dependent on the ability of the participants to use the technology. Many of the lawyers that I have dealt with, they carry their old paper bundles like some form of comfort blanket into the court with them, and have been very reluctant until COVID-19 hit us to learn new skills. So there are many commercially available platforms available. We have a smorgasbord approach to them at the present time, where the judge will, in consultation with the lawyers and the parties, decide which platform they are going to use. For example, if you have a client, a case that involves a person who doesn't speak the first language of the jurisdiction, so in England, many clients won't speak English and will have to use interpreters. Zoom has an interpreter channel, so the interpreter can speak to the party entirely separately and simultaneously translate. But of course, when that witness is giving evidence, the interpretation is heard by all rather than just by the person requiring it. So you have to pick your platform depending on your particular needs. Now, I said when I started that coming hand in hand with remote working, it becomes the need for electronic management of the court papers. If I'm sitting in my office 200 miles away from the court, I can't see what the judge is looking at. I can't see the piece of paper that the witness is looking at. I need to show the judge the paper I want him to see, or I need to show the witness the piece of paper I want her to look at. So working digitally has had to come hand in hand with working remotely. And that was, I would say, a bigger challenge to people. As it's already been said, using some of these platforms is quite intuitive, but learning how to put together a bundle of papers from hard copy papers and produce an electronically indexed court bundle is a different skill altogether, but it's a skill that everyone has had to learn, so the case can be presented in a way that is accessible. And the key word, the buzz, has to be accessibility for the court users. And I'm going to share my screen again. This time I'm going to demonstrate a different application, which is, I'm hoping that's the right one. No, not that one. Let's stop sharing. I'm hoping it's going to let me. No, it's not going to let me. So I'm going to be brave and I'm going to share my entire screen in the hope that you will then... No, I'm not sure it's going to let me do that either. Well, what I wanted to show you was a platform that an online platform, a cloud platform. I'll cancel that. A cloud platform we use regularly in the courts in England, where all the court papers are uploaded to a cloud-based system. Everyone has a login. You log into the cloud-based system, and so everyone sees on their screen the court papers, all beautifully indexed and accessible. in front of them. It's managed by the applicant, so whoever's brought the proceedings, brought the court application, manages the court papers, and it's all uploaded, secure, password protected, and it works beautifully hand in hand with remote working, because paper and video platforms, in my experience, simply don't work and do not do justice to the cases that require the sort of urgency that generates the need for the remote working in the first place. So unless I can assist you any further with what is happening in English Family Court, that is my presentation.
Okay, thanks a lot, Darren, for your presentation. This is unfortunate that you couldn't share and to show the bespoke system you've told us about. And there was a question from the audience. They said, do courts have their own budget to develop these bespoke systems?
The court service, was given a budget by central government to modernise. So they had a budget to develop their own bespoke system, and that was under development when COVID hit. They already had, the judges already had within their software packages from Microsoft, Skype for Business, and some had Microsoft Teams. What they don't have a budget for any other platforms. So the way that in the family court, on the cases that I've been involved in, have worked, is that the video platform is hosted by one of the lawyers, and the judge is invited in to the video conference, and it's hosted by one of the lawyers who has a subscription to that platform. Now, particularly some local authorities, some local governments have complained, well, that might give the lawyer hosting the event the ability to snoop privately in someone who might be in a side room within the platform or in a private chat within the platform. But my response is, well, I don't press my ear against your conference room in the court building, so why do you think I'm going to snoop on your privileged discussions using a remote video platform? We need to really be sensible in extraordinary times that we're in coming up with arguments that really are valid arguments rather than just reasons to be difficult.
Okay, that's interesting. Okay, and Stefan, Larry, do you have any comments? We have few from audience, but I wanted to ask if you wanted to comment or ask something.
I have a question. Darren, are there juries in any of the child or family courts, or is that all presented and judged by an individual judge?
No, so in the English Family Court, it's all a judge. Our criminal courts abandoned jury trials when the lockdown was imposed. They have in the last week, just over the last week, reintroduced them, but on social distancing. So jury members are not allowed to be within 2 meters of each other. There might be a jury in one room with a judge and a witness. There'll be other lawyers in a different room cross-examining via a video link from one courtroom to the other. So everyone's being spread out to maintain social distancing. So the criminal courts were very much interrupted, whereas the family courts, we pretty instantaneously switched over from in-person hearings to remote working. But obviously some judges and some lawyers were more able to do that than others. So I'm not saying it's been embraced by all by any means. And some people have to be, educated and assisted to manage the technology. But it's been impressive the way that the judges and the lawyers have made this technological advance almost, within days.
Okay, thank you, Darren. Stefan, do you have any comments?
No, not particular.
Okay, got it. So then I have a question from Swati. She's asking, can you go to ECHR for data breach cases?
I don't understand the question.
Okay. Yeah, I will read it once again. I'm also not sure if I can interpret it. Can you go to European Court on Human Rights for data breach cases? I think.
Well, I'm looking at the live comments now. It says, which platform are you using? Can one go to ECHR for data breach cases? I mean, even after Brexit, UK can still approach the ECHR. It's no part of my current role to adjudicate upon data breaches, if there have been any. As I've said, there's been concerns about the security of all the platforms over time, particularly Zoom to start with. There's been numerous updates by Zoom and indeed by some of the other platforms. You know, we are proceeding on the basis that once you're in the room and it's locked, that no one else is gonna get in. And I can say that I've not experienced any of our hearings being invaded by someone who hasn't been invited. The bigger concern has been ticking the terms and conditions box and signing away rights to your personal information. But I think many people have just, you know, any website you open, you tick the T's and C's without reading them. And I think people, again, are just taking, you know, sensible and reasonable approaches and not taking issues with that kind of difficulty, because we agree to T's and C's all the time. Any other questions?
Yeah, there was also a question from Judge from Dnipro that Ivar mentioned before. Andrei Rishenko, he was one of the first who used Zoom in Ukraine, and he asked, what about interrogation of witnesses in the video conference? But I think you also mentioned it quite thoroughly. I don't want. I'm not sure if you want to add something to.
Well, I mean, my experience, it works very well. We have had expert witnesses give their evidence by video link for years. So we are used to, but we would be in a courtroom looking up at a screen on the wall and cross-examining, interrogating the witness while they're on the screen. We've just moved to me sitting in my study, looking at my computer screen and doing the same task. And the same applies to witnesses, not lay witnesses, as we call them, you know, parties to proceedings. The skill in the cross-examination is all about preparation. It's all about identifying the correct points and skill in the task. The physical presence in the room with the witness does not define the success of the examination or interrogation of a witness. So I am very happy to cross-examine witnesses remotely, but I recognise that many of my, I've been in the job nearly 30 years, many of my contemporaries are wedded to the traditional way, as we've called it, and find it's quite difficult to contemplate they will be cross-examining someone without seeing the whites of their eyes, as it's been described on a number of occasions.
Yeah, I see. Thank you for your answer. Okay, there is one more comment from Saswati that says that Larry looks like George Martin, who wrote Game of Thrones. And I think with this comment, we can thank Darren a lot for his presentation and comments he gave, and switch to Larry, if you don't mind. Okay, thank you, Darren. I'll put now everybody back to the background before the Q&A session. Okay, Larry, the floor is yours, and you may share the screen.
Well, I only wish that I had George Martin's bank account, and then I would be happy to look like him. First of all, is my screen being seen? Are you able to see the screen?
No, not really. Not really.
Okay, let me get back to it. As I'm trying to figure that out, let me also say that I would like to take a bit of a different approach, although the experiences that we have are not at all unlike those that Ivar and Darren have shared. We had a very short period of time in which to make a transition. I think we were experiencing lockdown about the second week of March, and without the same degree of experience, I would say, that the UK judicial system and legal system has had in adopting technology. I think, to be all candid, we're significantly behind in the innovation field. The UK is definitely leading the US in that regard. And for that, I think it was a bit surprising to me to see how the value proposition of moving into the technical world in COVID was adopted so quickly without a great deal of agony. And it wasn't because people were anticipating it. So I'm going to ask again, are you able to see my screen at this point?
Okay. Yes, it works well.
Okay, good. Then I will proceed. So what I'd like to
go for it.
Sure, I would like to take a little bit of a different tack by simply saying, well, what are the lessons learned? And as we go forward, what might we find in the post-COVID era, whatever that is, although some would say there's never going to be such a thing. But nonetheless, the reality is that we've just undergone a tsunami. And I've never had to experience one, but these are photographs from the Indonesian tsunami of 2018, pictures from space taken in August as opposed to immediately after. And the reality is that something of this magnitude will change the waterfront. The things that we've grown accustomed to in the past, some of them will be obliterated because they weren't able to withstand the forces of change. And I think there's something similar that we're experiencing now, having undertaken these last 2 months of being forced to adjust to a new environment that we didn't anticipate and didn't prepare for. So these are some of the things that I've overheard in the last 2 months, mostly from lawyers, some from the public interested in legal matters. But this level of commentary to me suggests change is not only coming, it's here. When a lawyer says, why would I ever fly to a hearing again after having participated successfully in the first virtual hearing that a court sponsored? Or a law firm leader who says, after experiencing work from home, why do we actually need to be paying for all this space as lease arrangements are coming up? Or perhaps a mediator among the group of folks with whom I work regularly as the chair of the Alternative Dispute Resolution Commission here in Tennessee. It's all about alternatives to judicial solutions. Mediators are heard to say, I didn't know about virtual private break rooms, or questions about why our state is beginning to promote pre-litigation dispute resolution online, or ODR, taking matters, hopefully, that can be resolved without resort to a court through a technology-based approach that allows parties with disputes or claims to resolve them electronically, digitally, and asynchronously, or not at the same time. Most recently, our Tennessee Supreme Court began publicizing and broadcasting oral arguments for all to witness on Zoom, and even the United States Supreme Court has begun broadcasting not visually on Zoom, but audibly, all of which gives rise to the concern that we have to be aware of things like flushing toilets. The first argument to the United States Supreme Court was embarrassingly interrupted by someone who had forgot to mute their audio. But all of this suggests that there's an awareness that's grown, and it's particularly intriguing to me to listen to how judges are viewing this period of time. These are all statements from Tennessee judges about a month into their first experience with virtual technology as it relates to the business of the judicial system. One judge said, "I think this pandemic has made people in the justice system think outside the box more, and I think that will help us in the long run." Another says, "I've done motion hearings, even complex dispositive or determinative motions by Zoom video." Another said, "This technology is allowing people of all different ages and backgrounds to come together and keep the justice system rolling. And it will continue to expand even when we get back into the regular swing of things." And then a fellow dinosaur who judge in one of our courts in the state said, "I'm an old-fashioned guy, but this is becoming more the new norm of how the world operates, recognizing the inevitability of virtual courts." And finally, a judge here locally in the county in which I reside says, "There will be, or there may be, a place for the increased use of technology in the justice system even after the pandemic is over." These are indicators to me that the waterfront, as a result of the COVID-19 pandemic, will not go back to the way it once was, but will incorporate numbers of these newly explored and newly discovered technology tools to administer justice. If you haven't discovered, I encourage you to discover a UK-based work. Richard Susskind and the folks that work with AI and court innovations in the UK have launched a remote courts worldwide website, whose URL you can see on the screen, which has virtually daily postings of initiatives around the globe of court systems either experimenting with, regulating, or improving upon their delivery of justice in a virtual manner. For example, recently in our country, Florida conducted a bench trial, or as Darren was suggesting, a trial before a judge entirely on Zoom. So all of the witnesses, all of the arguments, all of the motions were visually and audibly conveyed by a Zoom conference. And I think we will find that to probably be the most likely survivor of COVID-19 in terms of the ease and the efficiencies which courts can now participate in, especially when there's no jury involved. But this is an example of the difficulties that are encountered when you begin to talk about juries. If you get the slides that have been provided for this presentation, this is an active link which you can click on to see a Texas jury selection process that took about an hour and a half. The first third to half of the time was spent by one of two judges. And if you look at the screen, you'll see the second to the right screen is the presiding judge over the matter that was in dispute. And on the top left, you'll see another judge. Her primary role was to ensure the adequacy of communications, the adequacy of both audible and visual, and having to help the potential jurors manage their technology and their environment in order to be participants. And I encourage you to take a look at it just to understand there will be difficulties when we expand the scope of the judicial process to include jurors. And in criminal cases and many civil cases in the United States, that's the case. But as Darren already said, the first socially distanced jury trial in the UK, accordingly, went like clockwork. And as I understand it, Darren has more details, of course, the jurors were using the benches that are available for legal counsel and the lawyers were relegated to private rooms, but digital was still a part of the process in order to convey a socially appropriate distance among participants because of COVID-19. And just today, the American Bar Association announced a webinar that it will conduct on June 11th about how to effectively conduct Zoom trials during the pandemic and beyond. So the US judicial and legal system is gearing up to move into a different set of tools and resources appropriate to the matter and the people and the legalities involved in any proceeding. And I'm virtually confident that Zoom will continue to be a prominent fixture of those processes unless and until other platforms arise that are better. So we're talking about a new normal. And there are elements of that new normal that we're beginning to see. But I would like to remind us that there are obstacles that we need to be aware of as we look at what might be life after the lockdown. Because in order for this to work, there has to be adequate and robust internet access through devices, whether they be smartphones, tablets, laptops, or desktops, that provide adequate visual and audible communication capabilities, which leads to a second question of bandwidth. And without appropriate bandwidth, and Ivar referenced that early, where in Estonia, Wi-Fi is ubiquitous, but in the Ukraine, as in the US, there are great swaths of our country that don't have access to Wi-Fi. So without adequate bandwidth, you're going to fail to provide justice for all involved. And don't forget how bias interacts. And there's been a lot of study done that the remoteness of sessions such as this webinar allow a greater degree of bias to entertain ourselves with respect to the first impressions that we might get from a talking head. It's not the same as being in person. And although it is certainly more than adequate, there is still the potential for unintended bias. And as in criminal cases, the right of confrontation of witnesses and those who say differently about things is guaranteed. And the worry that, in fact, that jurors might even in a Zoom conference begin to do their own independent Google research on a particular matter are things to be avoided because they can contaminate the process, as can crosstalk. For example, the use of private messaging between individuals that others aren't aware of. But at the same time, there are things that must be confidential, like counsel-client communications or jury deliberations. But at the same time, are we providing open access to the public at large for those things which are not confidential? The transparency factor has to be addressed, and we have to be able to recognize different requirements for different kinds of law, criminal law in particular. All of these things can be overcome, but we have to do so with an awareness of their impact. So I would like to take it just a little step further and say, now that we are more comfortable with technology, what might technology introduce into the judicial process that is available and could be of great benefit? For example, we talked about translation and the ability of Zoom to be able to connect with the translation service. Well, there are similar technology tools that can convert text to speech in different languages through natural language processing, and likewise speech to text. If you weren't aware, every Zoom conference can automatically create a transcript of the language being used, and it's an audible transcription. So the ability of natural language processing to create a record is part of the process. Unless you weren't aware of that, you have access to a tool in many of these platforms that could be of value. But now we're getting into some of the things that I think will be ultimately determinative in terms of how justice can be deployed. Machine learning and artificial intelligence in particular. The capacity to take things like technology, such as blockchain, artificial intelligence, and take all of the data that is being generated by these access to technology tools like Zoom. At this point in time, it is believed that digital data is doubling every day because of all of the recourse that we now have to internet capabilities. That data lake really needs to become a power generator. And that's the purpose and the effect of AI, to take all of that disaggregated data that is uncategorized, unclassified, and allow it to help us render justice more effectively. And these are just some of the kinds of data lakes that are out there, waiting to be energized through the application of artificial intelligence. I'm confident that as we progress with a greater comfort in the power of technology to assist, that artificial intelligence will help us make better decisions. Hear me say, not make decisions for us as judges, as counselors in law, but help us to make better decisions based upon the ability of data to be understood. So with that, I will be quiet and allow you to share any questions or observations if you wish. So, Dima, it's back to you.
Yes. Thank you so much, Larry. That was very interesting to me. And you were the first who mentioned AI. And some of people here on the comments also have a comment about technology. What do you think? How the future of justice should be? Should it be video conferencing based or VR based? We didn't touch VR at all.
Yeah, great question. Virtual reality is one of those technologies that I'm confident will become more prominent in the legal system. I think first we'll see virtual reality in training, in experiential learning for judges, barristers, trial attorneys, and others to engage hypothetically with a set of facts and then in real time display the capacity to deal with those facts as a lawyer would. But ultimately, why not allow virtual reality to become a form of evidence? Those are just questions, a lot of obstacles to overcome, but virtual reality is going to become increasingly common, I think, in our world as a training tool and as an illustration tool.
Yeah, very interesting. I was wondering, Darren, what do you think about VR? Because it seems that you are one of the first movers in technology, and you say that the need to pay your bills moves lawyers towards new technologies. What do you think about VR?
It certainly moves lawyers towards new technology. They have to pay the bills for sure. Whether virtual reality will be used to convene a virtual court. So I'm sitting at my desk with a headset on in a mock-up of a courtroom. I'm not sure. I think by the time we get to that stage, if a lot of court hearings have moved online to a video platform, we'll have become used to it, and we won't necessarily then need to feel that familiarity and that security of then placing ourselves virtually inside an old courtroom. I think we'll have developed a new skill set, and we will be happy looking at a screen. I agree with Larry that there's going to be very much of a mix of the old and the new. Some hearings we will still want that face-to-face experience. Case management hearings, I'm sure they'll be dealt with remotely. Why do we all need to drive or drive for miles to do that kind of thing? And some judges will be happy to do things a new way, and some will, as soon as they can, revert to the old way. So I think there's going to be a real mashup of experiences really for quite some time to come.
Agreed.
Interesting. Stefan, I was wondering, what are your reflections?
I must honestly say I completely disagree. Virtual reality, in my opinion, is not a tool for court hearings because the chances and the opportunities to manipulate the systems, the mimics of people, whatever, is so enormous that I cannot see that really. And I'm also very skeptical. I'm dealing, and my team is working with a lot of the AI tools, NLP, graph databases, and other things. But I'm very, very skeptical. I'm not sure, but not every one of you ever tried to live transcript a text from speech to text and check the quality. That usually is poor in terms of it's good in terms of what you would expect, but it's poor for the quality you would expect for a court hearing. So I think with all those tools, there's a lot of development to be done. Use translation engines like DeepL, for example, have it run from standard language, German to English, English to whatever, another French. You will see that the meaning of the text works enormously, even so the quality in principle is not so bad. So yes, using those tools helps in preparing for litigation, in reviewing and aggregating data, etc. But to have him live in a court session, I would not agree by knowing what the rate of error is.
Okay, thank you, Stefan. And Larry, you mentioned that probably, or was it you, Darren, who mentioned that probably the first way how VR would be used would be to get some skills and to get some experience in terms of learning, in terms of I don't know, maybe students studying new subjects or something. I know there is a startup from the Netherlands who are using VR to teach students and lawyers about court hearings. So actually, you can participate in a mock-up trial in VR. And you can select like options. What would I say to a judge, and where would I stand? These kind of things. So it is already happening, but yeah, there's definitely some precautions, as Stefan mentioned. Okay, we have a question from from Pablo from Colombia. Hello, Pablo, Juan Pablo Puentes Vargas. He says the justice system should not rely on proprietary software. The justice, as the rest of the public sector, especially essential services like justice, should be run on a Libre software. What do you think about that, Larry, first of all?
Well, clearly there is the potential in every proprietary endeavor for self-interest and the economics of prevailing from the standpoint of the incentives that a proprietary entity will be driven by. However, look at all of the proprietary tools that justice uses today. Courts don't create their telephone systems. Courts don't create their internet. Courts don't create all of the software that they rely upon to do their work efficiently. So there has to be both caution as well as comfort in the integrity of a proprietary application. And that's where I think we have to be, as members of the legal profession, most engaged, because every single software can be audited for purposes of the integrity with which it functions. And if we as lawyers are participating in and allowing the users of technology to be personally satisfied that the purposes to be served are exactly the features and the functionality that they're getting, then we can have a greater degree of comfort that the proprietary tools that also are ubiquitous and no court can work without are serving the purposes for which they are subscribed.
Okay.
The UK government, in the form of the court service, would entirely agree with Juan Pablo. comment, which is why it's set up its own the establishment of its own bespoke service. And the plan very much is, once that platform is good enough, that all court hearings will move over to it, and it'll be managed entirely by the civil service within the civil servants in the court service, and the professionals will just be invited. We'll get our hearing notice. It will be online, and we'll click the link and we'll be in. So that is very much the plan. It's just that the demands of and the speed that was necessary to get the system up and running has required us to use commercially available software until we have a bespoke, good enough option. I'm not even going to say better. I'm just going to say a bespoke, good enough government option.
Yeah, thank you, Darren.
Well, just one thing to add here. I think the distinction is it good? Is it safe? Is it transparent? Because in particular on court and other software elements, you would like to understand whether or not the software can be manipulated or not. But is it free or not is not so often a criteria, because most of the open source tools have a sort of a community version and then an enterprise version, and the enterprise version usually is not for free anyway.
That's a very good point, Stefan. And with your comments on this, I would like to switch to your part. Thanks a lot, Larry, for sharing this. And I've got your presentation. I've got some requests already to share it. I will share it later on with participants and with everybody who's joining us. So Stefan also has some experience with open source solutions, as he mentioned to me privately before. He said that he was using Jitsi for course, but also for universities. I'm really curious to know a little bit more about that stuff, and hope you will touch it. And before we also switch to your part, I also want to say that Stefan is a host of two wonderful conferences. One is Remap, which starts in a few days on 8th of June. Of course, this year it's going to be online, so I all encourage you to participate. I saw the lineup; it is great. And also, Stefan should have been hosting EMEA, European Legal Hacker Summit this Saturday already, but of course it was postponed because of COVID, and now figuring out how to manage it. So yeah, with these few comments, Stefan, I give the floor to you.
Thank you. Well, I try to share my screen. Please tell me whether it's working.
Yeah, it works perfectly.
Do you see it? That's good.
Yes.
Well, then let me start by thank you very much for this kind introduction and mentioning the conferences. Remap in particular is something I'd like to put to everybody. It is free access, and it really has the who is who in legal informatics. All the major professors teaching, from Kevin Ashley from the US down to people in Europe and in Hong Kong, will be here. We'll have the president of the ADM, Ms. Kotzitz, who will give a fireside speech. ADM is the largest computer association in the world. We also have the president of the International Artificial Intelligence and Law Association, Enrico Francesconi. So will be really great, I'm sure, and it's free. So if you have the time, please participate. But now to my slides and to my presentation. Let me start with two sort of observations before I sort of tell you what I'm up to. We here in Austria have the advantage that digitalization in law goes back for about 20 years. So every lawyer here is more or less for years now used to have court communication electronically. That means we upload our data, we download the decisions from the courts or whatever it is, from calling witnesses down to receiving the protocol, the minutes of a hearing, down to receiving decisions. The same applies also for most of filings with major authorities, in particular the financial authorities. So we are pretty much used to deal with electronic communication in that context. We have historically already had experience in, for example, video conference interviews of witnesses that usually was sort of, let's say you have a witness in Zurich that wasn't able to come to Vienna. That witness might have gone to a court in that country, and there was a video conference interface, and by using that interface court to court, the witness could be heard at a hearing. COVID, of course, brought another dimension. We, similar to what we heard already, had regulation that allowed to a certain extent to have hearings online by video conferencing mainly, and by the latest degrees, those regulations have been extended to the end of the year, and it requires certain prerequisites. One is in particular that the parties agree, that the parties have the necessary technical installation and equipment. Point Larry made already, sort of, everybody needs to have a fair chance to participate. And there are certain rights that parties can even afterwards object or bring additional arguments if they felt they haven't had an appropriate participation. Now, what's a bit surprising is that we are not having, and that's why I asked the question at the beginning, because I have the feeling nobody really has, we don't have clear criteria technically what such an installation needs to make available. What are the standards? What are the checks and balances you need to test in order to say a system is appropriate? And let me remind you, and that point was also made already before, there's a number one, there's a privilege of client-attorney conversation to be kept private, but there is also a privilege of not everything in a court proceeding is public. So, for example, the hearing might be public, the documents you file are not necessarily public. And the question is then, how do you make sure that such a system is also secure and appropriate, and, for example, can also be used by ourselves in communicating with our clients in preparation of the hearing in a way that allows us to meet the legal requirements by law that apply for us as lawyers to keep conversation and information exchange with clients confidential. And that's where we started off when we here in our firm discussed how we would like to run such communication. Now I'm, for example, acting as a receiver, and one of the conversations I just recently had with the judge who's considering to appoint me is sort of how would we communicate. So we agreed we communicate by video conference to the extent possible. But sort of he said, well, on court he has a Zoom installation. I said, well, I don't feel comfortable with Zoom. We have a different installation. So we left it at that he could test our equipment, and if he's fine, he's actually free to choose what he wants to use. Usually courts in Austria very often tend to use Zoom or Teams or other applications. We thought we go about that in a different way, and that's what I wanted to explain to you, and I wanted to show how we arrived at a certain decision. Now, like everybody else, we had a look around what are the tools, and here just 6 as an example. We all know there are more, and there have been, and we are on a different one here, for example, for the conference, and others had been mentioned as well. I think we thought we need to set our criteria. What do we want to have? We wanted to have secure communication. We wanted to have video and audio, screen sharing opportunity, the opportunity to chat, to raise your hand. We wanted to have high HD quality. Wanted to have functionalities like mute and unmute, turn off and on your cameras, a central administration, the ability, for example, to record conferences, and many other criteria we established. And we were looking around and arriving at the decision that we would actually want to use Jitsi, and Jitsi will make our friend from Colombia, happy because that's really open source and freely available. And there is, to the extent I know, not an enterprise version. So you really deal with that one installation. Now, why did we decide to use Jitsi? Not so much because it's open source. Open source was helpful, but it is self-hosted. It is self-administered, so you don't have an external administrator. It's password protected. It's encrypted. And it has all the other management functions I mentioned before. What was our experience when we installed Jitsi? There's a bit of good and bad. It's relatively easy to install. So if you have a reasonable software provider, and you have, it also has relatively modest system requirements, you have that installation done more or less in a day, and the cost of services, so rent your server, for example, and do the installation, we speak about 1,000 euros or 1,500 euros or something like that. So it's not enormously expensive. The quality is very good. Jitsi also can be integrated because we were looking also for communication tools that meet similar criteria. We came up with a communication tool that is direct and allows direct communication. So something like we run our own Slack platform or our own WhatsApp platform on our own server and integrate, for example, Jitsi that also runs on our own server, and combine those two tools into one, where we can freely chat, share documents, but also video conference and on a secure basis. So Jitsi has the ability to integrate, and it has additional tools like tools for recording and other useful tools, statistics, etc., that helps you to manage it, similar to a quality like Zoom is offering. Now, what's the downside? The downside is that as it is a community tool in a way, documentation is limited, and upon installation, you need to play around a bit with the various parameters that the system has until you find a form of installation that really meets all your criteria, is running, for example, with the lineability of your dial-in lines for the system, and that is having the necessary speed and reaction times, etc., so that everybody gets the feel. You know, you hear everything, you see everything, you're not getting missed. You can raise your hand in time and you're noticed. Your picture doesn't vanish, whatever. This needs testing in a more proprietary system. That would be part of the service you pay for, right? There's a bit of a downside. And if you're going to try Jitsi, I would advise that you read the various blogs that are around there and have an appropriate software person hardware or software person that does your installation. But generally, I think it is a very suitable tool for secure video conferencing in particular when you are willing to self-host, which I strongly advise to, because it's one of the few ways where you control manipulation, and it's also allowing you to set yourself the password criteria, for example, by which people can log in. The system is also insofar secure as a conference or a meeting is always only open for the period for which it is enacted, and it's closed afterwards and it disappears. So your login criteria will not allow you to early enter or to late enter, because it's only for that time slot the administrator makes it available to you, which is also sort of a security management issue. Now, is that secure to the utmost extent? Of course not, because like any other installation, there are issues like what line, for example, do you use to come into the conference? Even if the lines are encrypted, you know, there might be backdoors where encryptions can be overseen. So it would be even more secure if you have a VPN dial-up or direct dial-in, etc. And you could think about other tools to make it more secure. But generally, in terms of the criteria we had, the confidentiality and privacy levels and security levels we wanted to achieve, Jitsi was by far, I must say, by far over Zoom and other applications, the most appropriate system we could find. And we are happy in using it, and feedback is good, and we have no problem to host conferences with 40, 50 people on our own server for those purposes. And that's about what I wanted to convey. Yeah, and I'm happy for all your questions.
That's very interesting. Too bad that Ivar is not here with us anymore to hear his opinion. And would they consider Jitsi for their next version of their research? But yeah, what about you, Darren and Larry? Have you ever experienced open source software and Jitsi in particular? Did you use it?
I couldn't say with some confidence that if I asked any of the lawyers I work with to pay €1,500 rather than a £11 Zoom subscription, I can tell you which one they would choose at this current time. In the longer term,
that's a one-off investment.
Yeah.
The Zoom subscription is a monthly subscription.
Yeah. In the longer term, then
after a month, you've earned the money.
Yeah. In the longer term, certainly all these options are available.
Yeah. What about you, Larry?
Yeah, I have not used it. I'm glad to hear about it. I will certainly explore it. But what I think this illustrates is that technology is not a status quo product. It's constantly being improved, developed, and any deficiencies that we find with any application can be and should be addressed, as we watched Zoom address all of the issues relative to security that were announced and promoted. So the thing about technology that we should never forget is process improvement is the way in which we continue to make every technology better, and it can be done on a real-time basis. We don't do technology by waterfall anymore. We do it in an agile way, meaning we start with what we have, we improve, and whatever the deficiencies are, once they are identified, they can be addressed. And so that's what Jitsi apparently illustrates, and we're going to see incredibly more applications that could have value in the legal space. We just have to be judicious about doing what Stefan and his team have done in exploring its functionality, its features, and making decisions as to its appropriateness for their purposes.
Yeah, I see. Stefan, I was wondering, did you use any other platform before Jitsi? And what was the cost of transferring to Jitsi?
We are using in parallel several platforms for various purposes. So we are using Zoom, for example, if we are doing communication where we say, well, we are not so much worried about security issues, but it's rather an issue of have as many people as possible access to the platform. And can they easily log in through their local cloud system, because of course that might be much better line quality than if they have to dial in into a server that's hosted here in Austria, for example. We are using Teams. We are using several installations. Skype, of course, to some Skype Business, of course, is one of them. So it's really depending on what's the purpose. It is rather sort of for that particular area of client confidentiality and security that we have decided we would like to have that particular tool. And now the internal teams are using that platform anyway because it's around. But I'm reading at a technical university here in Vienna, for example, that we use Zoom for that purpose. We have Google Hangouts in the legal hackers environment, for example. So I'm fine with most of those platforms. It is just an issue that you always, as Larry rightly said, you need to figure out what is your purpose and what's then the right tool. And what I would strongly advise everybody is sort of organization like Legal Hackers with about 40,000 members globally. Those are sort of the environments where people figure out what's around and share their information, and that's how you also get to know sort of what is available. And yeah, we on a daily basis, Larry rightly said, on a daily basis, we need to check out what is new, what does technology offer to us, and what are the tools we can use to improve our services. And yeah, that's all good.
I got it. There is another question from Pavel. He's asking, what about stability of connection with Jitsi? Did you have any troubles before?
That at the beginning, that's what I was mentioning, or that's what I meant when I said, you need to play around with the installation. Yes, the Jitsi has a lot of tools and sort of boxes you can tick, and you need to figure out whether or not, for example, a certain element of the installation is absolutely necessary, because it might have an impact on performance. And we had that experience at the beginning, that we had issues with line quality, that obviously the lines were too much, too busy with certain elements of services, that other, for example, the picture quality wasn't good enough. But after a certain level of time and testing, we figured that out. So overall, the installation took a day. That the optimizing took another week or two, where people not full-time permanently optimized, but sort of played around. And there was a bit of testing, then there was another bit playing around. So that is something you need to manage when you self-host open source software of high quality. I must honestly say that is complex, but of course such teams do not have the funds available to offer documentation and 24-hour support that a professional service provider has. That however has other elements of services as well, because I personally always think, if something is cloud hosted and people tell me it's end-to-end encrypted, honestly, as a coder, I don't believe that. I believe you encrypt from user to machine server, and then from server to user. Your encryption on your system is very much in your own control, and whether or not there's a backdoor or not, you'll never know. If I run it on my own machine, I know whether or not there is a backdoor or not. And that's, for me, a big difference, right? So there are so many business models out there, and we all know nobody will get rich by just offering video conferencing. So there might be other business models as well, and that's, I'm not accusing anybody of anything, because I wouldn't be able to prove it, but I would always advise to be extremely careful in particular on cloud services, because there are commercial interests and there are state interests very often that interfere with that level of privacy. And to remind you, in the EU, we have every telecom provider has by law to provide the home state a backdoor to the systems, right? So no backdoor on my server. That would be my argument.
Well, that's an interesting insight. I had a question about the forthcoming conferences that you're going to be hosting.
Yep.
That should be quite an extensive one, I can imagine. And I was wondering if you're going to use Jitsi for that purpose or something else.
Something else. We use Hop-in2 in that case, which is a conference platform, which offers an environment where you really can mirror what a conference is doing. So you have a stage, you have side stages, you have live chats between the participants, like they could meet up, you have sponsor booths, you have streams for sponsors, etc. We had been like, that took us much longer. We had been on the lookout for an appropriate platform for a long time. That is a cloud-based platform, but for a conference, that's fine. And it is not absolutely free, but it's reasonable cost. And honestly, on the Legal Hackers event, which we plan by the end of July, we still, even when we think there will be a reasonable chance that people could travel to Austria and participate, that we would do it hybrid on a similar on that platform, because for those who can't travel for whatever reason, it is, I think, a real opportunity to have a very, very direct impression of what's the conference looking like. And we will have camera teams and a director that sort of is mixing the various shots the cameras are offering to give the audience a very much, to the extent possible, live feeling for the conference.
Okay, got it. Now I feel like we should be wrapping up because my family is already, and my daughter is already interrupting me. She's probably feeling that 2 hours is enough. So I want to thank you so much for your time and for your participation, for your great insights. It was a great pleasure to have you all, and Ivar too. I hope to see you soon on offline conferences and platforms, and hope you all stay well and healthy throughout this new situation in our lives. If you have any closing comments or thoughts, please go ahead.
Well, I'm just thankful to have been invited. I appreciate that very much, Dima, and appreciate getting to hear from experts like Stefan and Darren as well.
Well, it really was my pleasure. I think I learned a lot, and you know, it's great to see that there is a lot of testing and experience out there. And likewise, I enjoyed to be here, and thank you very much for the opportunity to participate.
Yeah, thank you for the invitation. I think our steep learning curve may flatten off a little, but I think there's still quite a lot of learning we'll be doing.
Yeah, I can't tell it better than you, Darren. Okay, thanks a lot, everybody, and yeah, keep in touch. Thanks.
All the best.
Good evening.
Bye-bye.